In the US in general, securities offered must be registered with the SEC unless an exemption applies, for instance if offered to accredited investors. But how to determine if a token is a security? A token can be an investment, right? And according to the Securities Act, an investment contract is a security. The US Supreme Court established a test called the Howey test to determine whether an arrangement involves an investment contract. It must be an investment of money in a common enterprise with the expectation of profits predominantly from the efforts of others. What else do we have? We have several statements of SEC Chairman Jay Clayton. He stated, for instance, that tokens and offerings that feature and market the potential for profits contain the hallmarks of a security under US law, which, to date, ICOs largely have been. With that being said, it's possible that an operational utility token, which, for instance, confer a right to access or license a system or use a system or its outputs, does not qualify as security. However, a utility token pre-sale will most likely qualify as a security because these investments are usually pursued with the expectation of profits. So this is where the simple agreements for future tokens called the SAFTs come in. These agreements for future tokens are offered to accredited investors. Telegram just recently raised 1.7 billion with these agreements. In order to comply with securities laws, they filed a D form. That's a notice for an offering exempted from registration requirements. To conclude, in the US today, token offerings usually trigger registration requirements unless the ICO is structured that an exemption applies.